This morning, the judge overseeing the Georgia election interference case dismissed 6 charges against Donald Trump and some of his co-conspirators who have been named in this case. Now, while this is a little bit of a setback for the prosecution, Trump is in fact still facing serious charges in Georgia over his role or his participation in the faux elector scheme and the Capitol riots that took place on January 6th. Now, here's what happened. According to CNN, Georgia Superior Court Judge Scott McAfee ruled that 6 charges in the 41-count indictment related to Trump and some co-defendants allegedly soliciting the violation of oath by a public officer lacked the required detail about what underlying crime the defendants were soliciting. So it all seems like it should be self-explanatory, but you've got to be super detailed in explaining what crime was broken and how that crime was broken. And so apparently the prosecutors didn't do their due diligence in that area as it pertained to some of the charges that have been dropped by the judge. Prosecutors had alleged that Trump and some of his co-defendants had basically broken the law by passing or pressuring members of the Georgia legislature to break their oath and unlawfully appoint an alternate slate of presidential electors that would certify the election in Trump's favor, even though Biden won the election. He won not only the popular vote, but the Electoral College, which is what matters the most. And so one count stems from the phone call that Donald Trump had made to the Georgia Secretary of State, Brad Raffensperger, on January 2nd of 2021. This is a video that we've shown you multiple times, but here it is again.
The ballots are corrupt, and you're going to find that they are, and which is totally illegal. It's more illegal for you than it is for them, because you know what they did and you're not reporting it. That's a criminal offense. All I want to do is this: I just want to find 11,780 votes, which is one more than we have, because we won the state.
A lot of mainstream media don't give you honest news. We do. You know why? Because of you. Paid membership on YouTube makes all the difference. Hit the join button below and you become the hero that sustains us.
So Trump and the co-defendants had basically filed motions called demurrers to have the charges dropped. And they succeeded to some extent. So McAfee argued that their legal teams, as written, the allegations that Trump and allies solicited Georgia officials to violate their oaths of office were too generic. That's the argument here. Too generic, too broad, not specific enough. You need more specificity in explaining why the prosecutors believe that these charges are just, and why Donald Trump and his co-conspirators broke the law, how they broke the law, and why these charges have been brought up. But it's important to also keep in mind that the judge is not saying that the prosecutors lack sufficient evidence of the crime. In fact, in the decision to drop these specific charges, it appears that the judge feels that there is adequate evidence. It's just that the prosecutors haven't been specific enough. So the court's concern is less that the state has failed to allege sufficient conduct of the defendants. In fact, it has alleged an abundance. However, the lack of detail concerning an essential legal element is, in the undersigned's opinion, fatal. Look, I'm gonna go off on a little bit of a tangent here and speculate on something, and I could be completely wrong, so just keep that in mind and take what I'm about to say with a grain of salt. Look, I'm concerned that the lead prosecutor in this case, the guy that was previously dating the DA in Fulton County, Georgia, and was named the lead attorney in this case, an incredibly important case. Nathan Wade, remember, did not have expertise in prosecuting RICO cases. His expertise was in personal injury law. And then he gets named as the lead prosecutor in this case. I'm wondering if these charges being dropped or the failure of the prosecutors to meet their requirements when it comes to these charges has more to do with the lack of experience demonstrated by Nathan Wade. Is that a possibility? And that's the reason why, guys, you should be really upset with the DA in Fulton County, because this isn't a joke. This is an incredibly important case. And if she decided to pick someone that she was dating to be the lead prosecutor in this incredibly important case, despite the fact that he might not have the appropriate expertise to try the case, you're gonna run into all sorts of issues. And you should be mad at the DA, not mad at the press for reporting about what the DA did. You get what I'm saying? Anyway, but let me continue. Let me continue. Because if you're confused about what this all means, I don't blame you. It is very confusing. So as written, these 6 counts contain all the essential elements of the crimes, but fail to allege sufficient detail regarding the nature of their commission, i.e. the underlying felony solicited. They do not give the defendants enough information to prepare their defenses intelligently, as the defendants could have violated the Constitution and thus the statute in dozens, if not hundreds of distinct ways. So that was a direct statement from the judge himself. And if you're still confused, I found this video to be super helpful. Here is CNN's legal analyst, Elie Honig, breaking down further why these specific charges were dismissed.
Georgia state law has this sort of unusual law that says it's a crime to solicit, to ask a public official to violate his official oath of office. And as Nick just laid out, there are 6 counts in this indictment that say Donald Trump and other defendants asked various members of the Georgia Senate and the Georgia legislature and the Georgia Secretary of State, other public officials, to violate their oaths to the Constitution by essentially swinging the election. But what the judge says here is, you prosecutors, you have to say what part of the Constitution. The judge says there are hundreds of provisions in the US Constitution and in the Georgia state Constitution. And the purpose of an indictment is to give defendants notice so they know what they're defending against. And you can't just say, well, you tried to violate the Constitution. The judge says what you have to say is what specific provisions of the Constitution, what specific sections of the Constitution. That's not in the indictment. Therefore, the judge says those charges are legally unfounded and now they're dismissed.
So the charges could be refiled with the necessary specificity that the judge is looking for. That's another thing to keep in mind. But now let's get into how many of the charges the relevant defendants have had dropped and what remains in this case. So of the 13 counts that Donald Trump and Rudy Giuliani faced, 3 of them were tossed out by the judge's order, meaning that they now both face 10 counts each in this case. The order also quashes one of the 2 counts against Mark Meadows, who now only faces 1 count for racketeering that all 19 of the defendants in this case are charged with. But the judge also said that prosecutors could seek a new indictment to try to reinstate the ones that he dismissed if they made the language more specific. And keep in mind that the call Trump made to Raffensperger can still be used as evidence in the case. It's not like that phone call is now null and void, totally irrelevant to the case. It could still be used. So the case will continue, but the scope of the indictment has been narrowed for now. And look, Trump and his co-conspirators are celebrating, and this is a little bit of a win for him, especially if the prosecutors in this case decide they're not gonna attempt to refile these specific charges. But remember, they're still facing a lot of very serious charges, and this is the state prosecuting Trump and his co-conspirators, meaning that if Trump ends up getting elected, if he's president again, he might be able to pardon himself from federal indictments, but he wouldn't be able to do so when it comes to indictments in a particular state. Now, some law experts say this isn't that big of a deal, including Anthony Michael Kreese, who is a law professor at Georgia State University and has been closely following the case. He says the following: I think it's a minor hiccup for the DA and less so signs of a fatal flaw. It was never particularly clear what constitutional theory undergirded the oath of office charges. I suspect the DA's office will button up their theory and go back to the grand jury. But again, unsurprisingly, Donald Trump is celebrating today. You have Trump and Giuliani's legal team basically thrilled about these updates. Let's go to Steve Sato, who is Trump's lead defense attorney. He says that the ruling is a correct application of the law, as the prosecution failed to make specific allegations of any alleged wrongdoing on those counts. The entire prosecution of President Trump is political. Listen, I think it is partly political, but I think there's merit behind this case for sure. But he says that it constitutes election interference and should be dismissed. So, and of course he thinks it constitutes election interference because he feels that the only reason why Trump is being prosecuted is to hurt his chances of getting reelected, when in reality, the exact opposite has happened as indictments have come in case after case. So look, again, I think that there is a political component to it. Politics is a dirty, dirty game. But I also think there's merit to this case. I just wish that they had the ball rolling a lot sooner rather than waiting until we get closer to the election to announce these indictments and to actually take Trump to court. But as Honig explains, the latest ruling is yet another unforced error for the prosecution.
There have been several screw-ups, frankly, by the DA throughout the history of this case. Going back to the investigative phase, the DA got herself disqualified from a small piece of the case because she created a political conflict of interest. The judge who was overseeing the grand jury removed Fani Willis from the case. We've seen Fani Willis make public statements in the church and elsewhere that have now been called into question that I think violate the ethics of prosecutorial rules. And now we've seen six of the charges thrown out of the case. And unlike the conflict of interest issue, this does go to the charges against the defendants. This does go to the indictment itself. And there is still a case. The lead charge, the racketeering case, is still in place, but this is a setback.
I think it was a terrible idea for Fani Willis to name Nathan Wade as the lead prosecutor in this case. A man that she had been dating, there's a conflict of interest there, totally a bad idea. I just don't think that this is a case that we should take lightly, and we should have prosecutors dotting their I's, crossing their T's, and being as thorough and careful as possible, because this is an important case, plain and simple. And it's really hard for me to not feel furious about how games are being played and like there's favoritism taking place with naming a lead attorney who I don't think is necessarily the right person to be the lead attorney, lead prosecutor in trying Donald Trump and his co-conspirators. But we'll see how this plays out. And I appreciate CNN and especially the honesty that we hear from Honig in his legal analysis, because I think there's usually an effort to provide cover for Fani Willis and the decisions that she makes, when in reality, we gotta call a spade, and if mistakes are being made, if dumb mistakes are being made, it should be called out. Again, this is not a case that you should be playing around with.